Dear students, welcome back to SWAYAM. Last class, we discussed about the introduction about intellectual property rights. Today, we are giving more emphasis to IPR laws in India. Today's agenda includes copyright law in India, patent law in India, trademark law in India, geographical indications of Goods Act, Design Act, IT Act. This intellectual property rights are legal rights granted to creators and innovators to protect their inventions, design, and artistic works. So, these rights will give exclusive control over the use of intellectual creations and encouraging the researchers and the innovators to have creativity and innovation while balancing the public interest. India's IPR framework, developed in line with the international agreements like TRIPS agreement, covers patent, copyright, trademarks, industrial design, and geographical indications. India has experienced a substantial increase in intellectual property filing in recent years. The government of India encouraging people, especially the researchers and the innovators, starting their startups and register their patents in various agencies like WIPO. The World Intellectual Property Indicators YP 2024 by WIPO highlights global trends in intellectual property filings that shows that India ranks 6th globally with 64,480 patent applications in the year 2023. And India also ranks 4th globally in trademark filings with a 6.1% increase in 2023. So, India's trademark office has the second largest number of active registrations worldwide with 3.2 million trademarks in force. So, the government's activities to improve the registration of the Patent Act. So, the government programs to enhance the patent registration, starting startup programs in universities and colleges, and opening the IPR cells in each and every higher education institutions has paved the way to increase the patent applications from our country. Now let us discuss. Indian Copyright Act of 1957 is a principal legislation governing copyright law in India. It was enacted to protect the right of creators in a variety of works, including musical, literary, artistic, and cinematographic works, as well as computer software. The Act provides authors and the creators with exclusive right to reproduce, distribute, perform, and license their creations, thereby safeguarding their intellectual property. The Indian Copyright Act 1957 has been amended 7 times since its inception. Indian Copyright Act of 1957 has been amended 7 times. In the years 1983, 1984, 1992, 1994, 1999, 2012, and 2021. The Act covers a wide range of works, including literary works, dramatic works, musical works, artistic work, and cinematographic films and sound recordings. Copyright grants creators exclusive rights over their work, such as the right to reproduce their work, the right to adapt, translate, or make derivative works, the right to perform or display the work publicly, the right to distribute copies of the work, the right to license or assign these right to others. So generally, the copyright term lasts for the life of the author plus 60 years. Now let us discuss what is the role of libraries in the copyright issue. Any document that is added to a digital library and make available for broader online use must have its copyright cleared, or it must be verified that it doesn't infringe upon the rights of the author or other owner. The following are some strategies for handling copyright related problems in the libraries, that are Creative Commons, fair use, licensed resources, written agreements and permissions. Now let us check one by one what is Creative Commons. Creative Commons provides licenses and legal instruments that allow authors to keep their copyright while allowing precise permits for reuse and remarking of their works. Creative Commons offers a more flexible alternative to the standard all right reserved structure, allowing writers to designate the terms under which their work may be used by others. It also allows creators to share their work more openly while having some control over how it is being used. Creative Commons provides six primary licenses that grant the public a fundamental set of reuse rights while ensuring proper attribution and safeguarding the original creator's work integrity. These rights encompass the ability to reproduce, distribute, communicate, make it available, and perform the work in its original form, at least for non commercial purposes, provided that appropriate credit is given. The six main Creative Commons licenses are CC by attribution, Creative Commons CC by SA attribution share alike, CC by ND attribution non-derivatives, CC by NC attribution non-commercial, CC by NC SA attribution non-commercial share alike, and CC by NC ND attribution non-commercial non-derivatives. We call it CC BY attribution. This permit allows for the broadest reuse flexibility, enabling others to distribute, modify, adapt, and build upon the work, including for commercial purposes as long as the original creator is credited. CC BYSA attribution share alike is a license that permits distribution, modification, and adaptation even for commercial use, provided that the creator is acknowledged and new creations are licensed under identical terms like a share alike. It is commonly used in projects aiming to maintain a free culture. The next is CC BY ND attribution no derivatives. Under this license, others can reuse the work for any purpose, including commercial use, but the work must remain unchanged and complete. Credit must be given to a original creator. Means they can use it for even commercial purposes, but we cannot make any changes in the content. And credit must be given to the original creator, original author. And next is CC BYNC attribution non-commercial. This license allows others to modify, adapt, and build upon the work for non-commercial purposes. New works must be credited by the creator, but are not required to be licensed under the same terms. Means in this license, a person having the right to modify, adapt, and build. And another license is given, that is CC BY NCSA attribution non-commercial share alike. This permit allows others to modify, adapt, and build upon the work for non-commercial purposes only, with the additional requirement that new work must be licensed under the same terms. And the last one, CCBY NCND, attribution, non-commercial and no derivatives. This license allows others to download and share the works, provided they credit the creator, but they cannot alter the work in any way or use it for commercial purposes. Next one is fair use. In India, the fair dealing provisions under the Copyright Act of 1957 regulate the use of resources for non commercial purposes such as research, private study, academic activities, review, or critics. These provisions restrict fair use to specific purposes, including personal or private research, criticism or review of works, and reporting on current events of affairs, which includes coverage for public lectures. These provisions restrict fair use to specific purposes, including personal or private research, criticism or review of works, and reporting on current events or affairs, which also includes coverage of public lectures. Next is license resources. Some documents come with specific permissions outlined by the copyright holders, specifying permissible and impermissible uses. Next is license resources. Some documents come with specific permissions outlined by the copyright holders, specifying permissible and impermissible uses. Based on these stated policies or licenses, such documents can be considered for inclusion in a digital library. Written agreements and permissions. For documents where copyright is retained by the author or publisher, written agreements with clear terms and conditions must be obtained before digitizing and adding them to the collection. Means if you are preparing your digital library before digitizing and adding to the collections, we should take a written agreements with clear terms and conditions. If there is a case, say if there is any case where the copyright has to be retained. Learners, next in the IPR Act, learners in the intellectual property rights in India, next we are discussing the Patent Act of 1970. The Patent Act of 1970 is a comprehensive legislation governing patent law in India, marking a significant setup in the country's approach to intellectual property rights. It was enacted to encourage innovations, protect inventions, and regulate the patent system in the country. The Act replaced India's earlier patent laws, including the Inventions and Design Act of 1911, and has since undergone several amendments to align with the international standards, notably the Patent Amendment Act of 2005, to comply with the World Trade Organization's TRIPS agreements. The major features of Indian Patents Act 1970 are: the Act outlined the criteria for potentiality, including novelty, inventive step, and industrial applicability. Certain inventions are not patentable, such as those that are frivolous, contrary to public order or morality, or cause serious prejudice to human, animal, or plant life. The Act allows compulsory licensing, enabling the government to authorize the use of a patented invention without the patentee's consent under certain conditions. It mandates that patented inventions must be worked in India within a specific period to avoid compulsory licensing. The standard term for a patent is 20 years from the date of filing. The Act provides a mechanism for third parties to oppose the grant of a patent. It includes the provisions for international cooperation and recognition of patents. The Trademarks Act 1999 provides legal protection to distinctive signs, symbols, and brand names used in commerce. Registered trademarks are valid for 10 years, after which they can be renewed indefinitely. A significant aspect of Indian trademark law is the recognition of transponder reputation. Even if a trademark is not registered in India, it can still be protected if it is well known globally. Furthermore, the Act guards against trademark dilution, ensuring that famous brands are not misused in ways that might harm their reputation or distinctiveness. Another one, Geographical Indications of Goods, Registration and Protection Act 1999. The last class we already discussed about what is Geographical Indication of Goods Act. Now we are discussing the Geographical Indication of Goods Registration and Protection Act of 1999 that protects products that originate from a specific geographic region and have qualities or a reputation attributable to that location. The Geographical Indications of Goods Registration and Protection Act of 1999 protects products that originated from a specific geographical region and have qualities or a reputation attributable to the location. Geographical indications of goods help preserve the cultural heritage and traditional knowledge associated with these products, while also providing economic benefit to the regions where they are produced. The Design Act 2000 protects the aesthetic features of a product's shape, configuration, pattern, ornamentation, and line or color compositions apply to products that, when completed, are purely aesthetically pleasing. Industrial designs play a crucial role in consumer products like furniture, automobiles, and electronic gadgets. The Designs Act 2000 grants protection for 10 years, which can be extended for 5 years more. This act ensures that product design innovations are safeguarded from unauthorized replications, encouraging creativity and innovation in manufacturing industries. And it was the older Act of 1911 was replaced on May 11, 2001, and the Design Act 2000 and related design rules. The 2001 took effect governing the registration and protection of industrial designs in India. And in addition to natural persons and other than the small entities, the most recent revision to the design rules went into effect on December 30th of 2014 and added a new applicant category, small entities. These are the amendments in 1911, then 2001, then 2014. Now let us discuss about the IT Act 2000. The drafting of legislation began in 1998 when the Ministry of Commerce proposed the E-Commerce Act. This draft was later revised into the Information Technology Bill of 1999. This underwent scrutiny by a parliamentary standing committee, which suggested modifications. After incorporating the IT Ministry's recommendations, the bill was approved by the Union Cabinet and both houses of Parliament. Following the President's assent, the IT Act came into effect on October 17, 2000. The Information Technology Act 2000 enacted and provide legal recognition for transactions conducted through electronic data exchange, electronic communication, and e-commerce. It aimed to replace traditional paper-based method with digital alternatives, promoting efficiency and modernizing communication and record keeping. The Information Technology Act 2000 supports digital libraries by providing a legal framework for secure electronic transactions, data exchange, and copyright protection. And it also recognizes electronic records signature, enabling secure access to e-books, e-journals, and other digital resources. By validating e-signatures, the Act ensures the integrity of information and smooth digital transaction, fostering trust in online library services. And this act also intersects the copyright laws to address the issue of digital privacy and the unauthorized distribution of e-books, e-journals, and research materials. The act also provides a legal structure for combating cybercrimes, including intellectual property violations such as unauthorized downloading and sharing of digital content. Feature of IT Act 2000 is its provision related to data protection and cyber crimes that helps libraries to safeguard user information, minimizing the risk of breaches in library management systems. That provides a legal framework for prosecuting cybercrimes, offering libraries protection against incidents such as hacking, phishing, and ransomware attacks. This act also promotes e governance initiatives which have significantly impacted the digitization of public and academic libraries. Let us conclude. India's IPR laws provide a comprehensive framework for protecting intellectual property across domains, from patents and copyright to trademarks, designs, and geographical indications. These laws not only encourage innovations and creativity, but also balance the needs of the public, especially in sectors like healthcare and education. India has made significant strides in strengthening its IPR framework by streamlining process, raising awareness, establishing IPR centers in universities and higher education institutions, and improving the enforcement, which has bolstered its global competitiveness. However, challenges such as piracy, counterfeiting, and ensuring equitable access to knowledge are still require more attention. By consistently enhancing its IPR policies and enforcement measures, India can foster an environment where innovation flourishes, benefiting industries, creators, and society as a whole. An effective IPR system not only protects the rights of innovators but also promotes for fair access to knowledge and technology, supporting countries' journey towards sustainable development. I repeat, an effective IPR system not only protects the rights of innovators and researchers but also promotes fair access to knowledge and technology, supporting the country's journey towards sustainable development. Thank you, my dear learners. I stop here. We will meet with another topic in the next class. Take care.